Wow, 50 years of bad federal judicial precedent has been overturned? Well, somebody sound the alarm. You're not supposed to be thinking with your finger in the wind, how do I best uphold the legitimacy of my institution? That is what undercuts your legitimacy, which is why Justice Roberts is actually a terrible, terrible justice. So the big news of the day is, of course, that the Supreme Court has not immediately enjoined a Texas state law that effectively prevents abortion after 6 weeks of pregnancy. And the reason that the Supreme Court did this is because of procedural mechanics here. So basically, the Supreme Court ruled, and the ruling was, it was a 5-4 ruling with, of course, Chief Justice Roberts joining the dissenters. It was the Republican appointees on one side, and then Roberts with the liberals on the other. And the basic scheme of the Texas law is why the law was not immediately taken up by the Supreme Court. So normally, in order for you to have a lawsuit that is taken up by an appeals court or taken up by the Supreme Court, you have to have somebody to sue, right? Just because you see something wrong in life does not mean that you get to sue. And the person that you sue has to be the right person. And if you're suing over a law, presumably, if you sue, for example, the person who is enforcing the law, that person has to have the power to enforce the law. So, for example, in Roe versus Wade, it was an official of government who was being sued in Roe versus Wade because it was that person's responsibility to enforce the law, so that person ends up as the defendant. This is usually the case when you have a case that's appealed to the Supreme Court, and it has to do with the law that is being enforced by the state. Usually, there's some official whose name you don't know who ends up as the defendant in that particular lawsuit. Well, Texas found a way around this, at least for the moment. It's sort of a creative way around this. The way that they wrote the law, it is not that the Texas state government is going to be enforcing the law. It's not like somebody comes to your door and takes you off to jail if you participate in the abortion process at 12 weeks of pregnancy. Instead, what the Texas state law basically did is it created a private right of action. The private right of action essentially allows anyone to sue a person in court who has participated in the facilitation of an abortion. According to Politico, individuals found to have violated that law would have to pay $10,000 to the person who successfully brings such a lawsuit. Right? So it's almost sort of a private bounty, in other words. So let's say that there's a woman who wants an abortion. I know her abortion doctor is providing her an abortion. I can sue the abortion doctor for providing her an abortion at 10 weeks, and then he has to pay me $10,000 for his violation of the law. According to Politico, anti-abortion groups in the state, such as Texas Right to Life, have in recent weeks set up tip lines for people to anonymously report violators ahead of the law's implementation. Earlier on Tuesday, a federal district court issued a temporary restraining order barring the group from filing suits against a small group of individuals and organizations that assist patients in obtaining an abortion, but both sides of the case acknowledge the order is very narrow, and the anti-abortion group said it still plans to solicit tips and bring lawsuits against abortion providers now that the courts have given a green light to the law's implementation. So, the Supreme Court majority does not say whether the law is constitutional. They just say that it is not clear whether they can take up the case because there's nobody to sue yet, right? Nobody has actually brought a lawsuit along these lines as of yet. So the Supreme Court found to prevail in an application for a stay or an injunction, an applicant must carry the burden of making a strong showing that it is likely to succeed on the merits and that will be irrevocably injured absent a stay, and that the balance of equities favors it, and that a stay is consistent with the public interest. The applicants now before us have raised serious questions regarding the constitutionality of the Texas law at issue, but their application also presents complex and novel antecedent procedural questions on which they have not carried their burden. So this is the Supreme Court saying, listen, we might not strike down Roe versus Wade. We might, in fact, strike down this law. But first, you have to go through the actual procedure of somebody having been grievously harmed by a private actor in this particular way. Because this lawsuit was, again, directed at a person, Austin Reeve Jackson, who's a judge. It's directed at a person who actually does not have the power to even enforce the law, per se. So, says the majority, federal courts enjoy the power to enjoin individuals tasked with enforcing laws, not the laws themselves. It is unclear whether the named defendants in this lawsuit can or will seek to enforce the Texas law against the applicants in a manner that might permit our intervention. The state has represented that neither it nor its executive employees possess the authority to enforce the Texas law either directly or indirectly, nor is it clear whether under existing precedent this court can issue an injunction against state judges asked to decide a lawsuit under Texas law, which is the person who was sued in this particular case. Finally, the sole private citizen respondent before us has filed an affidavit stating he has no present intention to enforce the law. In light of such issues, we can't say the applicants have met their burden to prevail in an injunction or stay application. Okay, then there were the dissents. And in the dissents, Justice Roberts didn't say that he would vote to uphold Roe versus Wade. He just said that he would put an injunction on the law pending some sort of resolution of the underlying issues. So there's the procedural issues, and then there's the underlying issue, which is really the one at the heart of the case, which is is it constitutional to pass a law that bars abortion after week 6? Now, look, from a pure constitutional perspective, the answer, of course, is it's fully constitutional. For the vast majority of America's history, there were abortion laws in virtually every state. And obviously, there is no right to an abortion in the Constitution of the United States. You can't point to it. You can't point to anything that points to it. It is emanations and penumbras and an idiotic Supreme Court majority in Roe versus Wade that literally created a right to abortion out of whole cloth. I mean, it's just created fully and just sits there like a turd at the bottom of the toilet bowl. That's how bad that decision. It is a terrible decision. Even people who are advocates of abortion generally recognize that Roe versus Wade is not a good legal decision. They just like the outcome. Okay, so as a matter of just what's in the Constitution on the underlying issue, the answer is, of course, Texas can pass this law. And California can also pass a law that allows abortion up till a particular point, maybe beyond, depending on what exactly California is doing and whether the 14th Amendment and the due process clause and the equal protection clause applies to the unborn, right? There's a strong pro-life case that the equal protection clause, right, that everyone is entitled to equal protection of the law, so far as life, liberty, and due process, for example, that should include the unborn, right? This is the pro-life case, that if you are a baby in the womb, you don't get to be killed just because you're a baby in the womb, right? You're an independent human life. You're protected by the Constitution of the United States. But putting that aside, if that is not the argument that is going to be accepted by the Supreme Court, for example, which it seems would be unlikely, if that's not going to be the argument accepted by the Supreme Court, the overturning of Roe versus Wade would not lead to a vast national ban on abortion. It would lead to significant restrictions in places like Texas, places like Georgia, places like Florida. It would lead to no restrictions in places like California because it would just get kicked back to the states. That was the situation before Roe versus Wade. There were very few restrictions on abortion in blue states, and there were lots of restrictions on abortion in red states. Okay, so Chief Justice Roberts says, I'm not going to even tell you how I'm voting on the underlying issue here. By the way, the majority said the same thing here. Roberts just says that he would enjoin it anyway. So Roberts says the statutory scheme before the court is not only unusual, but unprecedented. The legislature has imposed a prohibition on abortions after roughly 6 weeks, and then essentially delegated enforcement of that prohibition to the populace at large. The desired consequence appears to be to insulate the state from responsibility for implementing and enforcing the regulatory regime. The state defendants argue they cannot be restrained from enforcing their rules because they're not enforcing them in the first place. I would grant preliminary relief to preserve the status quo ante before the law went into effect so that the courts may consider whether a state can avoid responsibility for its laws in such a manner. Defendants argue existing doctrines preclude judicial intervention, and they may be correct. But the consequences of approving the state action, both in this particular case and as a model for action in other areas, counsel at least preliminary judicial consideration before the program devised by the state takes effect. So Roberts is fully admitting in his own dissent here that defendants may be right, that they are allowed to avoid culpability here because they're not the actual defendants. But Justice Roberts says, I'm going to intervene anyway because I prefer the status quo ante, which is pure Roberts, right? Roberts is mostly interested in preserving what he perceives as judicial legitimacy at the expense of actual judicial accuracy. Right? This is why he'll rewrite the Obamacare law in order to ensure that Obamacare remains the law of the land, despite the fact that it clearly violates constitutional provisions and separation of powers. Right? Because Justice Roberts is always thinking of the legitimacy of the... By the way, because he thinks like this, he has completely undermined the legitimacy of the institution. It turns out the only way to uphold the legitimacy of your institution is to strictly interpret the rules under which we are all supposed to live so that there is predictability to those rules. You're not supposed to be thinking with your finger in the wind, how do I best uphold the legitimacy of my institution? That is what undercuts your legitimacy. By the way, this is true as a human being as well. If you're constantly vacillating because you're trying to please people, people don't like you as much. People think you're illegitimate. People don't trust you. Okay, this is certainly true when it comes to institutions, which is why Justice Roberts is actually a terrible, terrible justice. In any case, he continues, I would accordingly preclude enforcement of SB 8 by the respondents to afford the district court and the Court of Appeals the opportunity to consider the propriety of judicial action and preliminary relief pending consideration of the plaintiff's claims. Because basically his argument is that it upsets life too much. If we don't intervene, it upsets life too much. Then there are the actual liberals on the court, and their dissent is basically we love abortion and abortion's in the Constitution, and this is a bad law, and so we should strike down the law. Forget about the procedure. The law needs to go because the reality is that imminent and serious harm are on their way, and we need to make sure that the quote unquote right to abortion is preserved. Right? This is the dissent. There's one from Justice Breyer. There's another one from Justice Sotomayor. Sotomayor, of course, is the most vocal, ardent, and screed-like. She writes the most screeds on the left of the court. She's sort of replaced Justice Ginsburg in that respect. She says the court's order is stunning. presented with an application to enjoin a flagrantly unconstitutional law, engineered to prohibit women from exercising their constitutional rights and evade judicial scrutiny, a majority of justices have opted to bury their heads in the sand. Okay, it's not flagrantly unconstitutional. Roe versus Wade is flagrantly anti-constitutional. It is a made-up law out of whole cloth, pulled directly from the colons of the justices in that case, particularly Harry Blackmun. But she says this is blatantly unconstitutional, which is a laugh since her actual care about the Constitution is basically zero. She says, last night, the court silently acquiesced in a state's enactment of a law that flouts nearly 50 years of federal precedents. Wow, 50 years of bad federal judicial precedent has been overturned? Well, somebody sound the alarm, because it turns out the court has routinely done that in cases where they've made bad mistakes before, namely Plessy versus Ferguson or Dred Scott. She says today, the court belatedly explains it declined to grant relief because of procedural complexities of the state's own invention, because the court's failure to act rewards tactics designed to avoid judicial review and inflicts significant harm on the applicants and on women seeking abortion in Texas. I dissent. Okay, so that is where things stand. Now, a lot of people in the media are reading this as though the Supreme Court of the United States is now going to knock down Roe versus Wade. I have serious doubts whether the Supreme Court of the United States is going to knock down Roe versus Wade. I think what they may do is rewrite the Planned Parenthood versus Casey standard, which is a really, really bad standard. The actual standard that may be curbed here is the so-called undue burden standard under Planned Parenthood versus Casey. So the Roe versus Wade decision sets up this ridiculous anti-scientific trimester system, right? Where the idea is that you could have some restrictions in the last trimester, maybe a few restrictions in the second trimester, and no restrictions in the first trimester. And then it sets up a standard of viability. And it says, well, until the baby's viable, you can basically do what you want. None of this is in the Constitution, of course. It's absurd. It's just made up completely. Then, in the early 90s, there's a case written by Sandra Day O'Connor and Anthony Kennedy and that whole clan. And the basic idea of the case is that the woman must never be unduly burdened, right? She can't be, that is the undue burden standard, that a woman cannot have to face down an order that has the purpose or effect of placing a substantial obstacle in the path of a woman seeking the abortion of a non-viable fetus. Okay, and it's a mess. I mean, that decision is a complete, absolute mess. There's a plurality decision. Okay, so majority found that a particular law was unconstitutional. 4 justices wrote or joined opinions saying Roe versus Wade should have been struck down. 2 justices wrote opinions favoring the preservation of a higher standard of review for abortion restrictions. It's a complete mess, right? It's just a complete and utter just bleep show. No question. The undue burden standard is what ends up emerging from this, right? You can't put an undue burden on a woman's right or ability to get an abortion. Now, the question is, that's really vague. What actually constitutes an undue burden? Where does that come from? Okay, so the court has been very unclear about this. Sometimes they'll say that something is an undue burden. Sometimes they'll say it's not an undue burden. Again, the notion that an abortion is a right to begin with is patently crazy. I mean, there's nothing in the Constitution that guarantees such a right. There's nothing in natural law that guarantees such a right. Where does this right come from? It basically came full-blown from the heads of a bunch of left-leaning justices on the Supreme Court. But it has now become a rote part of sort of leftist theology, and it really is a theology at this point, that abortion is an inerrant good. Abortion is itself excellent. And so you see people on the left consistently making this argument. Now, I just want to point out that by 6 weeks of pregnancy, the baby is already starting to develop like a lot. Okay, like the levels of development at this point in time are pretty high. So you keep hearing from people, well, most women don't know that they're even pregnant by week 6 of the pregnancy. Well, I mean, they've already missed a period, so there's that. But beyond that, there actually is some pretty significant development. Like the notion that this is just a cluster of undifferentiated cells at this point is just not true. According to the Mayo Clinic, right, which is not a right-wing site, last I checked, they say, week 6, the neural tube closes. Growth is rapid this week. Just 4 weeks after conception, the neural tube along your baby's back is closing. The baby's brain and spinal cord will develop from the neural tube. The heart and other organs are also starting to form, and the heart begins to beat. This is according to the Mayo Clinic. Now you'll hear from people on the left, well, it's not really the heart because the entire heart hasn't been developed yet. It's just it's the poles that will become the heart that are firing electrical signals. Okay, and? So? Structures necessary to the formation of the eyes and ears develop. Small buds appear that will soon become arms. Your baby's body begins to take on a C-shaped curvature. In week 7, the baby's head develops. The baby's brain and face are growing. Depressions that eventually give rise to nostrils become visible. The beginnings of the retinas form. Lower limb buds that will become legs appear. The arm buds that sprouted last week now take on the shape of paddles. Week 8, you've already got a nose for the baby. The fingers have begun to form. Small swellings outlining the future shell-shaped parts of your baby's ears develop. The eyes become obvious. The upper lip and nose have formed. The trunk and neck begin to straighten. Again, we are 8 weeks in. According to the left, you should be able to abort like pretty much all the way up to birth. There are no limiting principles for the left. But fetal development is extraordinarily rapid and pretty well developed, certainly by the time you hit the first trimester, for sure. Okay, but according to the left, this is just, Texas is evil, and Texas is terrible, and Texas is a disaster. And there's just article after article about this. Gail Collins says Texas is trying to overturn Roe versus Wade all by itself. She says Texas, and of course you get the obligatory, this just amuses me. You get the obligatory photo of the women in the Handmaid's Tale outfits. Okay, now just quick note. You can get an abortion pretty much anywhere in the country that ain't Texas. Also, quick note. The woman in the photo is wearing a Pride Progress face mask, a transgender rights face mask with a gay pride flag, rainbow flag, over her face in the New York Times photo that has been chosen. And this has become part of the broader left-wing rubric where they just create mad libs that don't make any sense when it comes to these issues. Right? So what they like to say, the original left-wing argument was safe, legal, and rare. Right? It's sad, but it's necessary in some cases. We'd like to make those cases less necessary. But, where a woman is having a really tough time, we can't burden her. It was a bad argument, but at least had some semblance of morality attached to it. Then we went from safe, legal, and rare to abortion is the greatest thing that ever happened. And now we've moved all the way to abortion is a woke issue that affects the intersectional coalition, which is like the weakest pro-abortion argument of all. At least the secondary argument that a woman needs to abort her baby so she can be successful in her career, which is sort of the argument you'll see made routinely by pro-abortion advocates. At least that argument acknowledges the logical consistency of I need to kill this baby so that I can get the promotion. That's, pretty cruel and terrible, but at least it acknowledges it. When it gets enmeshed in the entire intersectional woke rhetoric, it makes no sense at all. It just starts to be self-contradictory and very silly. Right? When you're declaring that men can be women, then it's very difficult to explain how this is a woman's right issue. When you're calling women pregnant people, very difficult to explain why this is a quote-unquote women's issue as opposed to just, a broad issue that affects both women and men and all the rest. My favorite line of this, and this is why I point out the gay pride flag this person is wearing while wearing the Handmaid's Tale outfit, is, again, once it gets enmeshed in the left-wing mad lib, it starts to make no sense. So Cori Bush, this is just a great example of this. She tweets out yesterday, the congresswoman from Missouri, the Black Lives Matter congresswoman from Missouri, she says, I'm thinking about the black, brown, low-income, queer, and young folks in Texas. The folks this abortion healthcare ban will disproportionately harm. Wealthy white folks will have the means to access abortion care. Our communities won't. Okay, so one of the arguments that is consistently made by people on the left is that black and brown women need to have lots of abortions. It is incumbent upon them. We need to protect their right to kill babies in the womb and to disproportionately kill babies in the womb. Now, you know who's cheering that? White supremacists. They are very happy to see black and brown babies die in the womb. And there were more black babies every year who are aborted in New York City than are born in New York City. And you can hear the white supremacists cheering. The notion that it is an inherent good for black and brown women to disproportionately kill their unborn babies is very weird. But put that one aside. I want to focus in on, this just shows what I keep saying mad lib because it really is. It makes no internal sense. Cori Bush here saying, I'm thinking about the queer people who are disproportionately affected by an abortion ban. I'm going to need an explainer on this one. Truly, I'm going to need an explainer on why lesbians are disproportionately affected by an abortion ban. Are lesbians accidentally getting pregnant at an outsized rate? How about like gay people and transgender people? Is that happening a lot? Really, is it disproportionately affecting the queer? I'm going to need some sort of understanding of how that works, according to Cori Bush. But it doesn't matter. Again, everything they don't like is about inequity because they don't want to get to the root of the issue, which is that they are fine with killing the unborn, right? That really is what it is. Some people are honest enough to do it. Mostly it's euphemisms. So the new euphemisms of the day are not women's rights. It's not safe, legal, and rare. The new euphemism of the day is it's inequitable. Inequitable. And it affects all the same people that every inequitable policy affects, including people who are gay, who are not getting pregnant accidentally, because that's not physically possible if you are engaged in homosexual activity. That's not how any of this works. So I found that hilarious and self-contradictory, but again, none of this has to make any sense. Did you know that every single like creates one additional leftist tier? That is just science.